Now, moving on to criminal litigation. Of course, I'll be giving you a chance to ask me questions, and please do feel free to ask me questions if you have. Now, criminal litigation assessment method. This is also known as a knowledge-based module. There are two parts: criminal litigation and criminal evidence. Both parts are equally assessed, meaning 50-50. No MCQs this year, as Abdul said, 60 MCQs. So I hope there will be 30 MCQs from litigation, criminal litigation, and other 30 will be from evidence. So both component parts should be considered as equally important. This is the other module controlled and set and assessed by the Barrister Board. As I said, all MCQs from this year, pass mark is again 60%. You must achieve 60% pass. So this is the assessment method in a nutshell. Now, why do we need a criminal justice system? Ultimate purpose is to put sentence if somebody is found guilty. So there are different purposes, at least 5 different purposes of sentencing: punishment of offenders, reduction in crime, reform and rehabilitation of offenders, protection of public, making of reparation to those affected by the offence. You will be dragged into those rules and purposes throughout your course. So don't worry, I'm not going to discuss in any detail. We'll be very much familiar with this throughout your course. So moving on. Types of offences. This is a very important aspect of this course. There are mainly 2 types of offences depending upon the mode of trial, meaning depending upon where the case is being actually dealt with, the venue of this trial. So depending on the venue of the case, this mainly can be divided into 2 parts. One, summary offence and indictable offence. Now, the term indictable is a sneaky sort of term. Indictable can be divided into another 2 component parts: indictable only and either way offence. So, summary offence are those offences which generally are tried in the magistrate's court. These are less serious offences. Now, indictable offences, if you consider indictable only, then the cases are tried in the Crown Court. It's the more serious offences. So we're pretty much clear about the 2 separate offences. Summary offence must be tried in the magistrate's court. Less serious offences, indictable only offences, must be tried in the Crown Court. Most serious offences, murder, manslaughter, rape, or offences along those lines. Now, there is another category in the middle. Depending on the nature and complexity of the case can either be tried in the magistrate's court or in the Crown Court. Let's say theft. Somebody can be prosecuted for theft for around £10. Somebody can commit an offence of theft for £10, or it can be increased to £10,000. Obviously, £10 and £10,000 are not the same figures. So if it is £10, inevitably this is going to be treated as a summary offence, and if it is £10,000, I suppose this will be treated as other indictable offence. So really depends on the nature and complexity of the fact. So based on that, a case can be tried in the magistrate's court or the Crown Court. So this is covered, either offences. So broadly, 2 offences: summary offences, indictable offences. Indictable offences carries 2 parts: indictable only and either way. Moving on to commencement of procedure. I'm not going to discuss in detail, just please do familiar with these terms. 3 methods of commencements: public prosecutions, which is written charge and requisition. Don't worry about the highly legal grounds of written charge and requisition, but do remember those terms exist for the moment. So public prosecutions, this is one of the methods of commencement of criminal proceeding. Private prosecutions, this is another way of commencing proceedings. Arrest followed by charge. So 3 different methods of commencement of criminal proceeding in English words: public prosecution, private prosecution, arrest, and charge. This was very important for the case, as I found. Some guidelines: read through Criminal Litigation and Evidence Manual, published by the City Law School in detail. Try to use Blackstone's criminal practice as much as possible. This is equivalent to White Book, which are used in civil procedure. So in civil procedures, we use White Books, Volume 1 and 2, and here Blackstone criminal practice is used to read for criminal litigation. Always remember tests and procedures, as we have discussed already. Maximize, again, your study combination between modules: criminal litigation and evidence, XIC, and XX meaning examination chief, which I believe Numan Bhai has discussed already. Examination chief and cross-examination, and of course conference. So criminal litigation, evidence, examination chief, cross-examination, conference. These modules, I found it, are very closely interlinked. If you have lack of knowledge of criminal litigation or evidential procedure, then you will be seriously struggling in examination chief, cross-examination, conference. So you must have to have a fairly good understanding of criminal litigation and evidence.